Honorable DM Swaminathan, you have 15 minutes. Before that, Deputy Chairman of the committee will take the chair.
I was told, excuse me, I was given 20 minutes for it.
Okay.
By Thank you, Mr. Chairman. We are now discussing the interim report of the interim committee that was submitted, which was appointed on the 23rd of September 2017. This committee was established by a parliamentary resolution on the 9th of March 2016, and it identified 12 main subject areas, and 6 subcommittees were appointed to deal with each of these areas. The reports of these subcommittees were tabled before the Constituent Assembly in November and December 2016, and the balanced 6 subjects which were not assigned to the subcommittees were deliberated by the steering committee and have now been presented to the Parliament. Mr. Chairman, the chapters 1 and 2 of the present Constitution, the subcommittee makes several suggestions, including 1. The sovereignty of Sri Lanka shall vest in the people and shall be inalienable and indivisible. 2. The Sri Lanka should remain one undivided, indivisible country. This perhaps is one of the main recommendations by this committee. There is also a recommendation that the maximum devolution should be granted and the constitutions shall be the supreme law of this country. There cannot be much argument relating to the provisions that the sovereignty should vest in the people or that the constitution shall be the supreme law of Sri Lanka. There also appears to be a unanimity in Sri Lanka should remain one undivided, indivisible country with maximum devolution being granted. In this context, it has become necessary to describe the nature of the state. Even in the United Kingdom, Mr. Chairman, which is considered the model of a unitary state, the concept of unitary state has undergone substantial changes during the recent past. And Northern Ireland, Scotland have been granted a great measure of devolution. Therefore, the singular term Ekitya Rajya has been used to describe an undivided, indivisible country. In Tamil, it has been transmitted as Orumitha Nadu. Therefore, it has been recommended that the following formulation should be considered. Sri Lanka is a free, sovereign and independent republic with an Ekitya Rajya or Orumitha Nadu consisting of institutions of the centre and the provinces which shall exercise powers as laid down in the Constitution. In this article, Ekitya Rajya or Urumitha Nadu, which means a state which is undivided and indivisible and in which the power to amend the Constitution or repeal or replace the Constitution shall remain with the Parliament and the people of Sri Lanka as provided in the Constitution. Therefore, it is clear that the recommendation is that there should be an indivisible state with an axiom devolution permissible by law. As far as the present Constitution is concerned, the maximum devolution has been laid down by the Supreme Court when it considered the 13th Amendment. The term Ekitya Rajya or Urumitha Nadu, which are the singular or Tamil words, are not terms of art. There is a difference of opinion by constitutional experts that these words have not been considered by any court of law and does not have any legal meanings assigned to terms such as unitary, federal, and union of states. Furthermore, when the singular or English word is incorporated in an English version of the text, there may be difficulties in interpretation which should have been addressed. The term Urumitha Nadu has been used in the Tamil version because it has been said that no better word could be found if the scholars are able to could be found. But if the scholars are able to suggest a better word in Tamil, which gives meaning for a state undivided and indivisible with a maximum devolution, then such term would have to be given due consideration. It has been suggested by some that the word Uruvittanadu has not precise legal meaning. There are some aspects which may require further consideration before a final decision is taken. Article 5 provides that no provincial council or other authority may declare any part of the territory of Sri Lanka to be a separate state or advocate or take steps towards the cessation of any provinces or part thereof from Sri Lanka. This would allay the fears of those who are of the view that the proposed provisions would amount to a setting up of a separate state. The recommendation of Article 7, which states that the national anthem could be sung in Tamil as set out in the third schedule, is certainly welcome and would be well received by the Tamil-speaking people of this country. Article 9 provides for the foremost place being given to Buddhism, but ensures that all other religions should be treated with honor and dignity, or that they should be granted the privileges and rights provided by Article 10 and 14, 1e. Therefore, the propaganda which has been taking place for some time that the foremost place given to Buddhism has been diluted is without any merit. Chapter 2 deals with the principles of devolution, and it recognizes the principle that in regard to center-periphery relations, more powers and authority should be devolved on local authorities, and the primary unit of devolution should be the provinces. There is a recommendation that the Constitution should not provide for merger, but in regard to Northern and Eastern province, whether they should be merged requires further consideration. A recommendation relating to inter-provincial cooperation, it should be noted that there is a specific recommendation that no provincial council or other authority may declare any part of the territory of Sri Lanka to be a separate state or advocate or take steps towards the cessation of any provinces or part thereof from Sri Lanka. It also recommends that the local authority should be the third tier of the government functioning under the provincial councils. The report also recommends that the division of powers between the several tiers of the government should be clear and unambiguous. This is one of the problems that is faced today under the present constitution in relation to center and periphery relations. Parliament should provide for the functions of the provincial council and the local authorities, but at the same time, national standards and national policy should be given priority. The provision that there should be reasonable minimum and standard of living throughout the country, and that there should be a reasonable minimum standard of state service delivery throughout the country, and a reasonable minimum standard of environmental protection throughout the country are welcome additions. The recommendation that the national policy should be contained in a separate article and should not be included in the reserve list is also welcome addition, and it is recommended that in regard to the national policy, the center of the provinces should adopt a participatory process. It also recommends that the formulation of the national policy on a provincial list matter would not have the effect of the center taking executive or administrative powers, and the provinces will retain executive or administrative powers with regard to the devolved powers. It is also clearly mentions that the national policy shall not override the statutes enacted by provincial councils in respect of matters of the provincial list. Therefore, it is recommended that the provinces should have a great measure of devolution subject to national policy, which again is formulated by a participatory mechanism, and with regard to devolved powers, provincial statutes would override any such policy. This is a step towards greater devolution to the provinces. The provision that the Constitution or the provincial statutes could not be done by a constitutional court within a prescribed period too is a welcome that it is given certainty to the provincial statutes, and it is also further enhances the principles of greater devolution of powers. In regard to state land, which is a matter of some contention today, that the national list state land is as provided by the Constitution, and acquisition of private property for the purposes of any matter in the national list would be subject to payment of just compensation. In regard to the state land, the provincial list provides that the state land and its use would be in accordance with the national land and water use policy, and any acquisition of private property should be with just compensation. The state land is given in the annexure, which includes the territorial waters, the continental shelf, that exclusive economic zone, foreshore mines, minerals. There is also special provision for the provincial administration to negotiate with the central government to release any state land to be used for the purpose of the provincial list, and the centre is also given the power to use state land. Further, the provision is made that all other state lands within the provinces could be used by provincial council, and distribution of allotments of land in land development schemes, it shall be after commencement of the Constitution and shall be in accordance to landless person, and such priority shall first be given to the relevant districts and thereafter to persons in relevant provinces and last to other persons. Mr. Chairman, there is also a provision made in regard to disputes of land between the centre and the provinces, and for the resolution of such disputes by a tribunal, the chairman of which shall be nominated by the Constitutional Council. There is a clear recommendation made that where there is a necessity for national security or defense, the President may, on the advice of the Prime Minister, direct the provincial administration to make available to the central government such land as may be required. Also, it is recommended that there is a National Land Commission to be appointed, which could be independent and would ensure equal representation of the central government and the provinces, and the functions of the National Land Commission are also reported in the report. Mr. Chairman, in regard to the executive, a decision has to be made as to whether the present presidential system of government is to continue, or prime ministerial system of government akin to the Westminster model should be introduced. There is a divergence of opinion between the two principal parties in this regard. If the presidential system is to be continued, then there are several matters to be considered, including what powers the president should have, and whether he should be answerable to the parliament, whether he should be elected by the people, or whether he should be elected by the parliament. In regard to the election of the Prime Minister, recommendations have been made. It could be by direct election of the Prime Minister, or pre-nomination of a Prime Minister, or as in the Westminster system, and the Prime Minister cannot be removed from office during the first 2 years except by a two-thirds majority or unable to secure the passage of the appropriation bill. Thereafter, the government may be removed by a vote of no confidence or failure to pass the appropriation bill. Due to recognitions have been given to women's rights, there is a proposal that a specific provision be made for women's representation in parliamentary and other elected bodies. This has already been done in the Local Government Election List Act. Therefore, Mr. Chairman, as set out in the Constitution, the matters that are being discussed today are suggestions that have been made by the steering committee, and this has to be submitted to the people or to the parliament as on the whole, and many other policymakers can make their recommendation in respect of the proposals that have been made by the steering committee. So the first principle is that we are discussing the issues that were made and the recommendation made by the select committee today. And with the recommendation made by the select committee, it is a duty of this parliament and also the duty of the other experts who are dealing with constitutional matters to come into this country, come into this, the facts of these constitution amendments and to report accordingly what steps should be taken as an amendments. These amendments will be considered again by this parliament or by the steering committee and be submitted to the parliament. And therefore, what we are now enhancing here is not what the papers or the media sometimes say, that there is going to be division of this country. Once you give the powers to the 9 provinces, the 9 provinces will divide the country. Some say that there is no proper status given to Buddhism. Buddhism has been given the utmost consideration in this constitution, and every member of the steering committee had accordingly suggested that it is the supreme law, supreme religion of this country. So there is no divergence of opinion regarding these fundamental issues that have been raised in this by the steering committee. The fundamental issues are there cannot be a separate state or it cannot be divided. The country is indivisible, indivisible country. Secondly, Buddhism has been given the utmost recognition. And few other issues like the presidential powers, how the Prime Minister is to be appointed, those are matters to be considered further as far as this constitution is concerned. Therefore, Mr. Chairman, we don't want to talk many more because this is only a preliminary discussion we have been having. This is only a preliminary matter that has been taken up by this parliament today, and therefore the suggestions that have been made by the steering committee should be further considered, and after further consideration, a due and a just final report could be submitted. Thank you.
Thank you very much, Minister.